Hello.
Good morning. This is Stephanie. I can hear you and I can see you just fine. Um, if you can change your screen name to your first and last name, just so it's clear, if you kind of hover over where you see your picture, there should be three dots at the top. And then if you click the three dots, then you can hit rename and then put your first and last name.
Testing, testing.
I can hear you. Are you able to hear me?
Yes, I'm using headphones
Perfect.
for more or less the first time ever,
Perfect.
but
Perfect.
I think they can help. At the last meeting, I couldn't hear the judge very well.
Mhm,
So.
mhm. Okay. And then I wasn't sure if you heard me in the beginning. Can you change your screen name to your first and last name, just so it's clear for the record who's talking for the court reporter? Tracy Belay is their court reporter. She's already on Zoom. So you hit the three dots. If you hover over your screen, there's three dots at the top right corner. If you click on that, there's a rename option. And then you can type your name in.
Okay, I guess fine.
Perfect. Thank you. And then we won't get started until just 9 a.m. when the the judge joins us.
Okay, who am I speaking to?
This is Stephanie. We had talked
Oh,
last week.
of course, I remember
Yep.
you. Thanks for all your
Perfect.
help.
You're welcome. You're welcome. I'm just going to mute and then you're welcome to mute and turn off your video if you want until the hearing starts. Otherwise, just know it is live. It is live streamed. So you are on YouTube right now.
Yep. Okay, great.
Perfect.
Morning. Can everybody hear me?
Yes.
Just to confirm, Ms. Kunkel, Ms. Boulay, are you both ready?
I am ready.
Yes,
Okay.
Judge.
Thank you. Good morning again. My name is Aviv Segev. I'm the administrative law judge assigned to this proceeding number 26F-0122EG. Today is Monday, July 20th, 2026. It is now 9 a.m. This matter comes on for a hearing pursuant to decision numbers R26-0259-I and R26-0410-I. I'm now calling the hearing to order. Before we start with entries of appearance, I want to inform or remind the parties and all attendees that it is the Commission's practice to webcast legal proceedings and that both the audio and video feeds of this proceeding are being live streamed. We're also recording the hearing, and we have a court reporter who is transcribing everything that is being said. To avoid background noise, please keep your microphones muted until it is your turn to speak. When you speak, please speak loudly and clearly, and please do not talk over one another so we can get a good record. Let's start with entries of appearance. Mr. Wagon, please.
I am Stanley Wagon of Silverthorne, Colorado. I lodged this complaint some time ago.
Okay, very good. Mr. Smith, can you please introduce yourself?
Yes, thank you, Judge. This is Ross Smith, Principal Attorney for Xcel Energy. I'm representing Public Service Company of Colorado in this proceeding, and I'm joined by my co-counsel, Emily Giraldo.
Very good, thank you. I'll try to briefly explain how this hearing will work. First, since you, Mr. Wagon, filed a complaint in this matter, you have the burden to prove that the allegations in your complaint are true. That means that you, Mr. Wagon, will present your case and including your exhibits first. You do not. You of course may testify and call witnesses. You do not need to ask yourself questions. You can just tell in a narrative form. Tell me whatever you think I need to know. If you ask for a document to be admitted into evidence, I will give a Public Service Company of Colorado, which I and anybody in this proceeding may refer to as the respondent or public service or Excel. I will give public service through Mr. Smith or Ms. Giraldo an opportunity to object. Mr. Smith or Ms. Giraldo can object if they believe there's a legal reason for why I should not admit an exhibit into evidence. Once you, Mr. Wagon, presented your evidence, it will be Public Service's turn to present its evidence. If Public Service asks for any document to be admitted into evidence, I will give you, Mr. Wagon, the same opportunity to make a legal objection for why the document should not be admitted into evidence. Again, you can object if you believe there's a legal reason for why the document should not be admitted. And when I say legal reason, I'm trying to differentiate it from you disagree with disagreeing with what the document says is not a legal reason for why it should not be admitted. Is that clear, Mr. Wagon? I'm sorry, you're muted. Okay.
One quick question, if I may.
Of course.
In my statement, can I refer to the company's exhibits?
Yes. Again, everything is subject to objections, but yes, you may, and yes, you may. I may ask some or all of the witnesses questions. That does not mean I'm taking sides. I'm just trying to make sure I understand the facts fully. As far as exhibits are concerned, I will generally admit into evidence any exhibit if it is relevant. Again, everything is subject to objections, but if the document is relevant, you can probably rest assured I will admit it, and I will, regarding its reliability or accuracy, I will consider those when determining the weight I would give the evidence. Mr. Smith or Ms. Giraldo, do you have, and Mr. Wagon, of course, do you have any preliminary matters you would like to discuss before we start with the evidentiary portion of the hearing?
No, Your Honor, no preliminary matters at this time. I have one small evidentiary matter, but that can wait until Mr. Wagon wants to use it, if we'd rather do it that way.
Okay, I suggest we reserve that. It may not be an issue, so
Absolutely.
for the sake of, all right.
And it's minor, so.
Understood. Very good. Mr. Wagon, any preliminary matters you would like to discuss?
I'm just not clear on the entire protocol. After various arguments are made, do you retire for a week or more to make a decision? There was a comment that we would get to make a written statement in 3 weeks. I'm not certain about that, so I don't know exactly how this works.
I don't believe in complaint proceedings, a written statement of position is not customary. However, I am willing to consider one in lieu of closing statements. In other words, I will not give you the opportunity to make closing statements, but I will give you the opportunity. I may give you the opportunity to submit written position statements and consider those before I issue my recommended decision. So again, if it's something that both parties would like, I will positively consider it. But I think it may behoove us to go through the evidentiary portion of the hearing and then see if there's a need, how the parties feel about it, and I will ask each of you at the end of the evidentiary portion if about that. So again, not customary, but not something I'm opposed to necessarily. Any other issues, Mr. Wagon? Very good. All right, so with that, let's move on to the evidentiary portion of the hearing. Mr. Wagon, are you ready to testify and present your exhibits?
Yes, I'm ready to go.
Would you please raise your right hand? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Put your hand down and proceed again to tell me whatever you think I should know and present whatever documents. You should know that I did read the complaint and your response to the motion for summary judgment. So I'm aware of the facts. But again, you should proceed with presenting all evidence you think I should know.
All right, thanks. I'm very grateful to the Commission and to Xcel Energy staff for arranging this hearing about an issue that concerns me. I'm Stanley Wagon of Silverthorne. I have solar panels on my house, but they do not meet all my energy needs. Since 2024, I have subscribed to an allocation of electricity from a community solar garden called a CSG, operated by US Solar. I pay US Solar under the subscription agreement, and the company applies a solar credit to my bill. This saves me 5% on my energy costs. I'm asking the Commission to examine whether the company is carrying out its part in the program correctly. I claim it is not. The error causes US Solar to sell me more electricity than I can use, causing me harm because of excess credit in my account. The main disputed issue is my claim that the annual net usage values calculated by the company and placed on its portal The mechanism by which the values are communicated to the CSG are artificially inflated. The CSG's allocation of electricity to me is decided on by US Solar, but Exhibit 202 by Diana Smith confirms that the company calculates and places net energy consumption data on the portal and that US Solar accesses it to administer the subscription. Therefore, the accuracy of the company's data matters. The statute is in Exhibit 101, which is just a copy of the Colorado statute. And it expressly has a sentence that requires that on-site solar be taken into account in a net usage calculation. My main complaint is this narrow question. When the company places a kilowatt-hour figure on their portal and calls it annual net grid usage for CSG administration, may it calculate that figure by replacing every negative time of use period value with 0. A simple hypothetical illustrates why this approach is wrong. Suppose that in a year I purchase 10,000 kilowatt hours from the company in the peak period, during which I send nothing to them, but in the off-peak period I export 10,000 to them while purchasing 0. The dollars won't balance because of the differing rates, but my net exchange of energy is exactly 0. 10,000 delivered by them less 10,000 delivered by me. But the company's method replaces the negative 10,000 in that period by 0, and the portal reports my annual usage as plus 10,000. This has nothing to do with billing. The question is whether plus 10,000 would accurately be my annual net usage and used to guide the allocation by the CSG. I claim that that is wrong. Let me now turn to my actual account. The company does not dispute that they use 0 instead of any negative numbers that arise. Their principal response is about an alleged double benefit that would accrue to me if they did it my way. Exhibit 205C by Ms. Merkel confirms that my excess production during certain time periods is taken to be 0 when computing net usage, and the company believes it is proper to replace such values with 0, thus removing some of my production from the overall net usage. I claim that this is improper. All of the company's accounting in terms of dollars is correct. The bills have many negative numbers, and I am properly credited for energy I sent to them, according to time of use. There is no issue regarding billing, but the CSG needs to know how much energy is consumed at my house, my annual net usage. My Exhibit 102 shows my October 2024 statement. I sold them 690 and bought 649. It is evident that my net usage is 649 minus 690, or negative 41. The company states, both in the billing statement and Ms. Merkel's statements in Exhibit 205, that my interpretation is wrong, and my net usage is really a plus 106. The company replaced 2 negative values in 2 periods by 0. Ms. Merkel gives a detailed analysis of the summer 2025 bill, where the discrepancy is 429 kilowatt hours, and states the following. Again, this is a reference to the company's exhibit by Ms. Merkel. Paragraph 9, the total net delivered by Excel is not intended to be a single figure computed by subtracting a customer's exports from the company's deliveries. Paragraph 11, the 429 kilowatt hours of mid-peak excess is not subtracted from the deliveries in the other periods. Paragraph 12, under Schedule NM, that 429 kilowatt hours of excess energy is neither lost nor ignored. It is converted to a dollar credit on his account at the rate. It offsets what he owes. This last concerns the dollars. My exports are properly taken into account for billing, but the company is ignoring some of my exports in their consumption calculation. Finally, in paragraph 13, she says, computing the total net delivered by Excel, as Mr. Wagon proposes, would give him the benefit of the same excess energy twice. once by reducing the kilowatt figure reported to his CSG, and a second time as a dollar credit that rolls forward. The company's method gives the customer the value a single time in the manner Schedule NM prescribes, and in the manner chosen by Mr. Wagon. This again confuses money with energy. The supposed first benefit identified by Ms. Merkel is not compensation and is not a benefit. It is just an accurate measurement of my usage. The dollar credit is the only compensation. Correct measurement and compensation are not the same thing. Paragraph 15 confirms that the total net delivered by Excel values that I see on my statements are actually used in the numbers placed on the portal. That paragraph claims that the same method is used for dollars as for kilowatt hours, but that is false. The dollar accounting properly uses negative numbers. The energy accounting does not. The exhibit quotes the net metering tariff in Exhibit 203.
Mr. Wagon, you're muted again. I don't know if it's something you pressed by accident.
Yeah.
I believe it's only the last 5 or so seconds.
Yep, I touched my mouse pad. Sorry about that.
The last thing that was on the record is the exhibit quotes the net metering tariff.
The exhibit quotes the net metering tariff. That tariff is about billing and concerns only the finances of the back and forth flow of energy. It does not address the calculation of usage. Exhibit 107 and by Exhibit 107, which is an email from Diana Smith to me, and paragraph 12 of Ms. Merkel's exhibit state the company's belief that by net usage for the 13 months starting March 2025 is 17,200 kilowatt hours. The actual net usage for that period is 16,100, as shown in my data in my Exhibit 104. This is a 7% error, which is not huge, but it adds up over the years. I accept that some figures near 30,000 kilowatt hours were caused by extrapolation due to a billing discontinuity. Perhaps such discontinuities will not arise very often. The company might consider correcting a method that produces values twice as large as the actual values. But my dispute concerns that 17,200 figure and the underlying method. After learning of my concerns, US Solar did reduce my allocation, but that is not retroactive. And Exhibit 110 shows that my credit jumped in a 12-month period from $35 to $628. A secondary point is whether the commission can ask that the company buy back some of my excess credits. That is part of my complaint, but much less important to me than the determination that their usage calculation is incorrect. The company has suggested that I work with US Solar to adjust my allotment, but this is neither practical nor fair. I have no access to the portal's data. Perhaps the company could arrange that a subscriber gets such access. And asking me to communicate with US Solar several times a year to address the company's error does not seem appropriate. Finally, I will explain why this is not merely a problem about one customer. The zeroing out of negative values can affect any enrollee in my position. Also, the SRCS tariff in Exhibit 204 is relevant. Page 2 there imposes a 200% cap on CSG credits. If the annual usage figure is overstated, the percentage limit will also be overstated. Thus, a customer could get credits in a way that violates the cap imposed by the commission-approved tariff. I believe the commission has an interest in seeing that the administration of the program follows the statute and is fair to the customer. Therefore, I ask the commission to find that a figure calculated by replacing negative time of use periods with zero is not an appropriate way to calculate net energy consumption for use by a community solar garden. Thank you all.
Thank you, Mr. Wagon. All right. I think I followed you. We'll do it. So you've given me what is probably more akin to an opening statement, a very detailed opening statement. So which is appreciated, and again, I think I followed you. I think it would be. Would you like to present any exhibits to support what you just told me?
Yes, let me only mention, I uploaded to box.com many
Of course.
exhibits. Let me only mention the ones that I refer to. Just give me a moment.
And as you refer to the exhibits, they will be displayed. I will ask you to tell me what the document is and how it's relevant to your case. Point any important things about the document, and then I assume that you want me to admit it, and so I will ask Mr. Smith or Ms. Giraldo if they have any objection, and we'll go from there. So we'll do it with respect to every document you wish to present as an exhibit. Okay. So the first document is what is its title or its
right. Exhibit 101 is an excerpt from the statute
101.
where it says that on-site let me just get it up on my second computer.
You can just view the Zoom screen. In fact, it's the preferable way so that we all talk about it. We know we're talking about the same thing.
Correct. You have brought it up, and there it is. I put in red the key sentence of the first paragraph, and perhaps I should have said the second paragraph indicates that if I die tomorrow, and I just had my 75th birthday, any excess credits do not come to my estate, but they go to somewhere else.
Okay, so you again would like me to what's been marked as hearing exhibit 101 into evidence. Is that correct?
Yes.
Any objection, Mr. Smith?
Just a small note of clarification, Judge. I would first note that this is the 2024 version of the statute, which under the Commission's rules is not the one that is used by the Commission. So we don't have an objection if administrative notice is taken of the current version of the statute. I would also note that this version that we see here before us has been modified by Mr. Wagon, which is not, so it's not a direct printout. So, but otherwise, as to the content of the statute itself, the company doesn't object to that.
Okay, all right. So, and Mr. Wagon, do you have any comment on that? Do you agree with generally agree with what Mr. Smith has just said?
Yes.
Okay, very good. So I will take administrative notice of the current statute, and I will also admit what's been marked as hearing exhibit 101 into evidence. So what's been marked as hearing exhibit 101 is admitted.
Okay, and 102 I referred to. I would like to admit that. That is a copy of my October 2024. I use the word statement to mean billing statement.
Okay, very good. Just hold on a quick moment. Is that the statement you were referring to? What's being exhibited on the screen right now?
Correct, and marked up to explain the zeroing out that occurs with the 2 zeros in blue.
Yeah, the hypothetical. And you'd like
No, excuse me, it is not hypothetical. This is the actual billings statement.
Understood. The 2 zeros in the blue, the kind of towards the bottom of the chart is the actual net metering usage. Understood. And you'd like me to admit what's been marked as hearing exhibit 102 into evidence?
Yes.
Mr. Smith, any objections?
No objection, Judge, just with the clarification that Mr. Wagon provided that it has been modified by him, but other than that, no objection. just wanted to note.
Understood. So what's been marked as hearing exhibit 102 is admitted. Any additional documents?
Yes, 103 is essentially the same thing, and I want that admitted because that is the one that Ms. Merkel discusses in great detail.
Okay. (103). Okay. So that is another billing statement. I see the markings in red and blue on the right side, and there's one also on the left. And that's what you would like me to admit into evidence, Mr. Wagon?
Yes, please.
And Mr. Smith, any objections?
No objection aside from the, again, same clarification that it's been modified, but no objection.
Understood. What's been marked as hearing exhibit 103 is admitted. Any additional documents you wish to admit, Mr. Wagon?
Yes, I didn't refer to all of them, but of course I care about all of them, and since they might arise, I'll probably go through all of my exhibits. 104 is a chart that I made. And these numbers come from my statements. So these are my numbers in the middle column, and on the right are the numbers from several documents the company has sent me, but those numbers are also available from my statements.
So this is a chart that you created based on statements, based on billing statements you've received. Is that correct?
Yes.
And you created it in anticipation of this proceeding. Is that correct?
Yes. I should say I keep track of my data over a period of years, so I have all this stuff, but I extracted this data as it is relevant to the disputed number of 17211.
And thank you, understood. And you'd like me to admit what's been marked as hearing exhibit 104 into evidence. Is that correct?
Yes, please.
Any objection, Mr. Smith?
No objection. I would just note that as you correctly identified, Judge, this is derived, the underlying information that was used to produce this document has not been offered. But other than that, there's no objection to it being admitted in this hearing.
Understood. Thank you, Mr. Smith. What's been marked as hearing exhibit 104 is admitted. What is your next exhibit, Mr. Wagon?
Well, it addresses the point Mr. Smith just said. Exhibit 105 shows the raw source data provided by the company that I used in making that chart.
Okay, so
this was sent to me by Diana Smith at some point. There's a slight glitch near the end because 2 months are combined into one, but this is basically a screenshot of material that I believe appears on the portal. Yes, I call this portal data.
and the markings in red it's your typing, right? Is that correct?
That is correct. I did the sum to show it sums to the number in question, and that little 4479 plus 570 is because of an extra month that somehow got in there.
And that's based again on information that was sent to you directly by the company. Is that correct?
This is the information sent me by the company.
You said it's a virtual screenshot of that information.
That is correct.
Okay. And you'd like me to admit this into evidence. Is that correct?
That is correct.
Mr. Smith, any objection to what's been marked as hearing exhibit 105 being admitted into evidence?
No objection, Your Honor, although I will note that this again is a screenshot of an alleged communication between the company and Mr. Wagon. It does not contain the original communication, but other than that, I trust Your Honor to give it the weight that it is entitled. So I no objection.
Thank you, understood. What's been marked as hearing exhibit 105 is admitted. Any additional documents, Mr. Wagon?
Yes, the next one is 106, and I would like to admit that because that just justifies the 570 that was pulled apart in the previous exhibit. This is from my billing statement and shows that I understand the numbers correctly.
So again, this is a part of a billing statement. I understand that the red markings are yours. Is that correct, Mr. Wagon?
Yes,
And it's okay. Is there yeah, there is a date. So you said that you would like me to admit this. Mr. Smith, any objection to what's been marked as hearing exhibit 106 being admitted into evidence?
No objection, Your Honor.
Hearing exhibit, what's been marked as hearing exhibit 106 is admitted. Any additional documents, Mr. Wagon?
yes. Exhibit 107 is an email from Diana Smith to US Solar and to me, confirming the number she believes to be correct and explaining that she tried to put that number on the portal, but it did not work.
So that's an email that was sent to you by Diana Smith, who you believe to be an Excel Energy employee. That email was sent on what date? Let's see. May 21st, May 21st, 2026. Is that correct?
Yes,
And you'd like me to admit this document into evidence?
yes.
Stephanie, if you would scroll up, I think it says 107, just to make sure. Yep. Mr. Smith, any objection to what's been marked as hearing exhibit 107 being admitted into evidence?
No objection, Your Honor, but one clarification. I think you said that the email had been sent to Mr. Wagon. I would just note that the email was actually sent to the subscription support team, and Mr. Wagon was CC'd, so no objection on that basis, but I would just like to make that clarification.
Understood. And thank you for that clarification. What's been marked as hearing exhibit 107 is admitted. Any additional documents, Mr.
Yeah, maybe we can do 108 and 109 at the same time. They are just screenshots of portal values, showing values that are gigantic. Now, I understand it's not part of my main complaint, but I would like to get them on the record.
I'll
Okay.
show 108 first. I just can't do two at the same time.
Okay, so detailed, valid. Mr. Wagon, can you again explain to me what this document is?
Yeah, this is a screenshot from the portal. The portal contains a lot of information that Excel places there and US Solar sees. Excel sent me two screenshots showing very large values. This is one of them.
Okay, this is
And
one, two.
yeah,
Sorry, go ahead.
well, this also contains information about how the solar garden allocates. So you can see it. It says that I get 0.13% of the total from this garden. So that's interesting. But my main point here is to show the very large number on which the 0.13% is based.
Understood. So what's been marked, any objection to what's been marked and the red rectangle around the figure 31,728.0 that is you're doing, is that correct, Mr. Wagon?
Yes.
Okay. And Mr. Smith, any objection to what's been marked as hearing exhibit 108 to being admitted into evidence?
Well, Your Honor, I'm not sure, given I think I trust I trust you to give it the weight that it should be afforded. I would note though that I think I could properly raise an objection to relevance. Mr. Wagon himself just stated this was unrelated to his complaint. So with that being the case, I think that I'm not sure that it's proper that it be relied upon as an evidentiary exhibit. But
I think I think I understand where you're going. I will nonetheless admit it, and I think, like you said, I will give it the appropriate weight when I consider when I consider the evidence.
Understood.
Um, yeah, yeah. So what's been marked as hearing exhibit 108 is admitted. And I'm assuming hearing exhibit 109 will look pretty close to the same. Mr. Wagon.
Yes, it is identical. But let me say a little complication. If it should happen that you decide that some buybacks of credit or some financial exchange coming to me is justified, then it gets a little tricky because some of the excess credits are due to these um, extrapolation errors. And it may be impossible to tear it all apart and figure out how much is due to that 7% number, how much is due to this, how much is due to that. And Excel just gave me a nice credit because of a power outage. So it's very difficult to look at a bill and figure out what's going on. These numbers could help you.
I understand, and that is why I have admitted 108, and we'll see what Mr. Smith says about 109. Okay, so Ms. Kunkel, can you please put 109 again on the screen? Okay, so again, the marking in the red rectangle on the bottom of what's been marked as hearing exhibit 109 is your doing. Is that correct, Mr. Wagon?
That's correct. And the source is identical.
And Mr. Smith, I assume that other than the similar objection you made to 108, you have no objection to the admission of what's been marked as hearing exhibit 109. Is that correct?
That is correct, Your Honor. I would, however, note just as for both of these, it's not an objection, but just as a point of clarification that again, this information is one part of the information. This isn't an actual, this is an excerpt from the entirety of what's on the portal. But no objection, just with that point of clarification.
Dude, what's been marked as hearing exhibit 109 is admitted. Now you, Mr. Wagon, referred to as you referred to the document that's been marked as hearing exhibit 205 by the company. Mr. Smith, do you intend to present it in your case?
Yes, Your Honor. Exhibit that is one of the exhibits that we anticipate moving for admission during our case.
Okay, so I think we can hold off on 205. Any other documents? Yeah, go ahead, Mr. Wagon.
Yeah, just one more, the very last one, and that is just to get on the record how my credits changed in a 12-month period. I understand it can be difficult to pull apart all these credits in terms of their sources, but this is what I see on my statement, and that would be Exhibit 110, which is a 12-month comparison.
So this is a billing statement for you, Mr. Wagon, right? By Excel. Is that correct?
That is correct. It is two statements separated by a gray bar.
I see that. I see that. So you cut and paste these the portions of two Excel statements. Is that correct?
Correct.
And let me see. The date is on it. and your name and address are on it. And the blue markings around in the top right corner, the one that says negative $35.02, and in the middle, the date that says March 4th, 2025 through April 24th, 2025, as well as the figure negative $627.72, as well as the it's hard for me to see, but it says read dates 3/30/26 through 4/28/26, 29 days. This is all you're doing. Is that correct, Mr. Wagon?
That is correct. These are April statements, 1 year apart.
Any objection to what's been marked as, and I'm sorry, I lost is it 111? No, 110, sorry. Any objection to what's been marked as hearing exhibit 110 into evidence, Mr. Smith?
No objection. Again, clarification that these have been modified and are not the entirety of the statement, but otherwise no objection.
Understood. What's been marked as hearing exhibit 110 is admitted. Let me see here. Mr. Wagon, have you told me everything you want to tell me today?
Yes, I have. And those are all my exhibits.
Okay. So between your statement and the exhibits, there's nothing else you want me. I mean, you will still have an opportunity to respond to Mr. Ross or Ms. Giraldo's questions, but there's nothing else and perhaps my questions, but there's nothing else you would like me to know upfront.
That is correct.
Okay, very good. Mr. Smith or Ms. Giraldo, do you have any cross-examination questions for Mr. Wagon?
No, Your Honor. The company is going to waive cross of Mr. Wagon.
All right. I actually think I might have a few questions for Mr. Wagon. So hold on just a quick moment. Mr. Wagon, I'll ask you a couple of questions, if I may. So, you've referenced, the statutory provision 40-2-127. I also think it may not be the updated version, but it may also be the in hearing exhibit 101. Could you explain to me how you believe that statute or any other legal authority, it doesn't have to be that statute, required public service to act once it became aware that the annual net usage information was inaccurate?
Well, they do not believe it is inaccurate. That is the crux of my complaint.
Okay.
I think it is noteworthy that whoever drafted that statute was well aware that there is a net versus gross issue here. At first, I thought the company was simply posting gross numbers because all I saw was that 30,000 and 29,000. And the company, in their motion to dismiss, observed that they are not posting gross numbers. The statute says they have to net this out. There is no point in me buying electricity that exceeds my needs. That is why that sentence seems critical.
Understood. Thank you for that. I think I understood and followed your question, your response, Mr. Wagon. I believe Mr. Smith's hand is up. So How
Yeah,
can
yeah.
I?
Yes. This is very minor, Your Honor. I was going to ask. I don't believe Mr. Wagon was sworn in, and I just wanted to raise that. If I don't recall him
He
being
was
sworn in at the
sworn in.
beginning, he was.
I
Okay.
did.
I apologize.
It's okay. I do tend to forget things.
No,
Today I didn't.
that's my fault. Apologies for the interruption.
That's okay. No problem. Okay. I think I may have another. Mr. Wagon, I appreciate your response. And we'll of course consider it. Um, I Another question. Is it your understanding that US Solar relied exclusively on the information displayed in public services portal, or do you believe there's another source for determining your annual net usage rate?
Good question. They have I assume they have an automated system. I'm pretty sure of that. That system adjusts my allotment whenever new numbers go on the portal. I think new numbers go on the portal monthly, although I'm not certain about that. However, they've been very helpful to me when I told them that essentially no household in the state of Colorado would use 30,000 kilowatt hours in a year. They said, oh, yeah, you're right. We'll reduce it to something more reasonable. I should add that I spot all this because they take money out of my bank account. When they take more money out, that is, they sell me more electricity than I expect, I take notice. So to answer your question, yes, they will listen to me. They don't have to. By law, they can ignore me. They don't have to talk to me. They could simply say, XL told us you need 30,000 kilowatt hours, and we are going to sell you 30,000 kilowatt hours and take that money out of your account. I believe they could legally do that, at which point I would have to resign from the subscription because it makes no sense. So yes, the primary method of communication of their allotment is this portal. But I call their customer service and they say, yeah, you have a point. We'll reduce you.
Okay. And it is my understanding, based on your testimony and the filings in this case, that ultimately public service sent the correct annual usage information to US Solar. Is that correct? I may be wrong about that. So let's answer that question first.
Yes, that is a good point. That email by the company accomplishes several things. It tells US Solar the number that they believe to be correct. Of course, I think that number is wrong. So that 17,000 figure is stated in several of their documents that they believe that to be correct. I believe it to be wrong. They asked US Solar to ignore the 29,000 and 30,000 and replace it with 17,211. Their portal would not allow them to do a manual insertion. Maybe that could be fixed. But they failed to put the 17. So as far as I know today, as far as I know, the number 29 or 30,000 is still on the portal. They also said in this email that Mr. Wagon believes the correct number is 14,000 and something. So he can chime in. But I didn't chime in at that point because my feeling is it's not my responsibility.
Okay. I thank you for that. Well, let me ask you a hypothetical. If it is, I understand fully that you disagree with the corrected annual usage, with what Excel sees as the reported corrected annual usage. I understand that they say X and you think it's a Y figure. If it is determined that Excel's X figure is actually correct, do you believe that that is still insufficient?
If it is determined that that figure is correct, then I would have to withdraw, and I would withdraw the complaint.
Okay. So that's the okay. Okay. You've answered my question. I appreciate that. I think I may have one last question, but I need to think for a second. Can you again? I think you've touched on it. You've more than touched on it, but if you can clarify just a little bit, how do you know that the incorrect portal value, as opposed to some other factor, caused your subscription agreement to remain at the previous level?
I have charts that I maintain of how many dollars I pay each month, and it just skyrocketed approximately a year ago. It should be roughly $100 a month. It went to 400, and that's when I called US Solar, and they said, "Well, your portal shows you as using 30,000 kilowatt hours." Now, I might have some of the numbers wrong, but the point is my communication with US Solar said that we are allocating you this. We are, and the comment was made, we are allowed to allocate to you 120%. Actually, it's 200%. The tariff was adjusted. So they are allowed to, in fact, they could take that 30,000 number and sell me 60,000 kilowatt hours. I would object, of course, but the actual tariff, this is not meant to be an exact thing. Nobody can predict how much electricity I will use in the coming year. All they have to go on is how much I used in the past year. Anyway, to answer your question, which I believe was, how do you know? US Solar told me.
Okay.
And US Solar said, we will try to work with Xcel Energy to understand this ridiculously large number. And they just failed to do so. So it's coming down to a private citizen. I mean, honestly, I feel that this is a matter between the commission and the company. But the commission was unaware. So the whole purpose of my entrance here is to make the commission aware of what is happening.
Okay. Okay. I think I understand. And yeah, I mean, typically you would have an opportunity for a redirect, but I think I've given you the opportunity to respond in full to each one of my questions. So, anything else related to my questions that you would like to add, Mr. Wagon? You can take a minute, a few seconds, if you would, to think if there's anything else you think I should know.
I've stated all the facts as I understand them, and they all seem pretty clear to me that I am right. However, I did not address what the remedy should be if it is determined that 17,000 figure is wrong. I vaguely tried to make an understanding of how an accounting system could be changed. That could be a hugely expensive proposition. It's not my job to tell Xcel what to do exactly. I did mention in my statement a couple of small things that could be part of a remedy, like giving me access to the portal. I think I said something else. I can't remember. In any case, it's not for me to insist that Xcel change its entire accounting system. It's also possible that you will decide, oh, this is so small, it's not worthy of inflicting a remedy. I guess I'm getting into a closing statement sort of thing. I just wanted to present the facts as I understand them and show that the numbers are wrong and in a substantive way.
Okay. Thank you for that. I appreciate that. So you have no other evidence to present, is that correct, Mr. Wagon?
That is correct.
All right. Thank you very much for your testimony and the presentation of your exhibits. I think unless is everybody ready to proceed with the next phase of this proceeding? Mr. Wagon, or would somebody like a 5 or a 10 minute break? Mr. Wagon, would you like a break or are you ready to proceed? Ready to proceed. Okay, Mr. Smith, any thoughts?
That's fine. We're ready to proceed, Your Honor. If Your Honor would like a 5-minute break or so, we are also fine with that.
I think we're good to go. How many witnesses do you expect on?
3, Your Honor.
All right, so maybe after the second witness or something like that, we can take a short break so everybody can freshen up. Okay, so let's move to Excel's presentation of the evidence. Mr. Smith, you may call your first witness.
Thank you, Your Honor. The company calls Emily Merkel at this time.
Hello.
Hello, Ms. Merkel, please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you very much. You may put your hand down, and Mr. Smith, the witness is yours for a question.
Thank you, Your Honor, and welcome. Good morning, Ms. Merkel. If I could start, I'd just like you to state and spell your name for the record, please.
Sure. My name is Emily Merkel, Emilymerkel, Merkel.
Great. And by whom are you employed and in what capacity?
I'm employed by Excel Energy as a supervisor in the contact center.
All right, perfect. Thank you. And did you cause to be filed in this proceeding what has been previously marked as hearing exhibit 205? There is both a public and a confidential version, I believe, that were filed in this.
Yes.
Okay. And Miss Belay, could we please bring up the public version of hearing exhibit 205, please?
It would be Ms. Kunkel. Ms. Boulay is
apologies.
I don't think either one of their feelings was hurt. So,
as you can tell, I've been a little out of practice in the hearing department for the last few months. So, apologies. And Miss Merkel, do you recognize this as hearing exhibit 205?
I do, yes.
And if I were to ask you questions, if I were to ask you the questions or the response about the responses you've provided here, do you have any changes to make, or are they otherwise accurate?
They are accurate. No changes.
Okay. Okay. With that, Your Honor, I would move to admit hearing what has been marked as hearing exhibit 205 into the record.
All right. Thank you for that. Mr. Wagon, any objection to what's been marked as hearing exhibit 205 being admitted into evidence? I saw your response and I understood it, but can I get a verbal one for the record?
I have no objection.
Thank you. So what's been marked as hearing exhibit 205 is admitted.
Thank you. And we can take this down, Ms. Kunkel. All right. And with that, Ms. Merkel, I have no further questions for Ms. Merkel at this time on direct. Ms. Merkel is available for cross-examination or questions from Your Honor.
Thank you for that. Mr. Wagon, do you have any cross-examination question based on the short testimony she just gave to Ms. Merkel? I don't know if I mentioned that.
I do not.
You do not.
Thank you.
And I just need to look at my notes. Okay. Go ahead, Mr. Wagon.
A question. What was just entered into evidence? Is it merely 205 or is it 205 and also 205C? I understand the C is confidential and this is a public hearing, but the numbers in C are relevant.
Understood. So when I admit a document, that's a good question. When I admit a document, I admit both versions. The fact that it cannot be displayed or discussed in an open session doesn't mean that I will not consider the confidential version. So when I say hearing exhibit 205 is admitted, it's both versions. Both versions of it are admitted, unless unless we specifically state that I will not allow one or the other for whatever reason. That's not the case here. So both versions are admitted, and that's a good clarification. Ms. Merkel, I did have a question for you. I believe in hearing Exhibit 205, you indicated that the company explained the period-by-period netting methodology to Mr. Wagon in written correspondence throughout this dispute. May I ask what correspondence you were referring to? Is there a specific email or set of emails?
I'm not sure. Hold on. What paragraph is that in?
Let's put on hearing Exhibit 205, please. And if I may have misspoke, but I don't think I did. So. I don't know what page it would be on, but let me open it.
I can stop sharing and find it. What was the verbiage that you were looking for?
Correspondence. If you would just look for correspondence or written correspondence, I think you might find it.
It's page 6.
Thank you very much.
Paragraph 16.
Thank you. So do you see in paragraph 16, it says written correspondence in the second and third line, Ms. Merkel?
I do.
May I ask what that correspondence is?
Sure. I'm not exactly sure how to answer that question. I believe he was corresponding with other people within the company.
Okay.
It was not with me directly.
Yeah, Your Honor, I believe I might can offer some clarification if I may.
Go ahead, please.
I believe what Ms. Merkel is referring to is the totality of the correspondence that Mr. Wagon has had with other Excel witness essentially with the company. I think I believe if I remember correctly that's what Ms. Merkel is referring to, but she is welcome to correct me on that.
Okay. And any correction, Ms. Merkel?
No.
Okay. Okay. Let me take a look a little bit. I may have another question for you, Ms. Merkel. Just hold off if you would, please. All right. I think I'm done with my questioning for you, Ms. Merkel. So unless is there a redirect, Mr. Smith?
No, Your Honor.
All right. So thank Ms. Merkel. Thank you for your testimony. You're excused. Mr. Smith, you may call your next witness.
Thank you, Your Honor. The company calls Diana
Actually,
Smith.
I'm sorry. Mr. Wagon, I think I did give you the opportunity to cross-examine Ms. Merkel. I think you indicated that you did not, or did you?
I did have 0 questions, but you raised the issue of paragraph 16. Paragraph 16 correctly says that there was correspondence on this matter, but the detailed statement that we zero out the periods, the phrase period by period, that was made very explicit in Ms. Merkel's statement in a way that I had deduced, but I had not seen before. So I appreciate that level of detail as it helps me. But to say it was explained to me in detail, I certainly didn't accept the explanation in any way as being correct. There was correspondence on the matter, but the fine detail occurs only in Ms. Merkel's statement.
Okay, okay, understood. Thank you. Thank you for that comment. And as I said, I'm sorry, Ms. Merkel, you're excused. Mr. Smith, you may call your next witness.
Thank you, Your Honor. The company calls Diana Smith to the stand.
You? Smith, would you please raise your right hand? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much, Mr. Smith. The witness is yours.
Thank you, Your Honor. And good morning, Ms. Smith. And we're not related, but great last name. Could you please state and spell your name for the record, please?
Yes, my name is Diana Smith. First name is spelled Dayannna. Last name Smith.
Thank you. And by whom are you employed and in what capacity?
Yes, I am employed by Xcel Energy, and I am part of the, my title is Product Operations Specialist, more specifically with the subscription management.
Thank you. And Ms. Kunkel, if we could please bring up what's been marked as hearing exhibit 202. We have a public version, I believe, in our box. That would be great. And Ms. Smith, do you recognize what's displayed here on the screen?
I do.
And did you cause to be filed in this proceeding? And I believe this was as part of the company's motion for summary judgment, but this is what has been marked as hearing exhibit 202, and this is your affidavit. Do I have that right?
That is correct.
And sitting here today, do you have any corrections to make to the content of this affidavit?
I do not.
Okay. Your Honor, I would move to have this admitted into the record. As I've stated, it was already attached to the company's motion for summary judgment. We are offering it here today just to ensure that all of the documentation from that is included.
Thank you. Mr. Wagon, do you have an objection to what's been marked as hearing exhibit 202 being admitted into evidence?
I do not.
All right, so hearing exhibit 202 is admitted.
Thank you. And Ms. Kunkel, we can take this down. Ms. Smith, I have one very brief direct question for you that I believe has been raised tangentially in this proceeding thus far, and I just wanted to get some clarification. Is it, to your knowledge, being the company's subject matter expert on these subscription providers and the communications with them, is it possible to grant a customer access to the portal that reports the data to CSG providers from the company?
To my knowledge, no, it is not possible. Granting access granting access for the portal will provide access to the customer for every customer involved or enrolled in subscription.
Okay, perfect. So just to clarify, so doing so would give a customer the ability to view all of the other customers in the CSG subscription. It would give them the ability to view all of that data, correct?
Correct.
Okay. That is the only question that I have. Your Honor, Ms. Smith is available for cross-examination or your questions.
Of course. Mr. Wagon, do you have any cross-examination questions for Ms. Smith based on her testimony?
Sure, yes. I understand that you cannot give a customer access now, but is there any reason the system could not be changed the way your system of billing exists to give only me access to my account to, I guess I'm saying, to make this part of the billing statement? Or otherwise give just, in other words, what would be involved in giving me access legally?
I'm not entirely sure, Mr. Wagon, because that is not part of my role, unfortunately. That would be more of IT personnel in determining that. As of right now, there is no way to provide access to a customer.
Thank you. Nothing else.
Ms. Smith, I do have a couple of questions. So it is my understanding that after Mr. Wagon asked for a correction, you Excel manually corrected the figure, but then it was reverted to the old incorrect number. Somehow the net usage figure was reverted. Is that correct so far?
Yes, sir, that is correct.
Okay, so after that happened, did you consider any other methods for ensuring that US Solar would continue to use the corrected rather than the incorrect annual usage figure?
Yes, sir, which is why that email was sent out to US Solar with Mr. Wagon CC'd to make them aware of the situation.
Okay, so that, okay. Was the inability to permanently change the value due to system limitations, or because is there some policy that prohibits it, or why is that? Why is there an inability to permanently change that figure?
Yes, sir. That it was relayed to me by our IT personnel that system limitations prohibited that change.
Okay. Okay. So it's system limitations. Okay. I may have one more question. Is there any mechanism that you are aware of that's available to public service to make sure that this figure or annually reported usage figures are not reverted? It may be an IT question, so answer to the best of your ability.
I'm sorry, can you repeat the question again?
Does public service have a mechanism to prevent their reported annual figures from being reverted after they're being manually corrected?
I believe that would fall under IT. That's not part of my day-to-day role. We did try to get that changed, but like I said earlier, the system did not allow that.
You did try, and you assumed that it would remain corrected in the statement and not revert. Am I putting words in your mouth, or are you agreeing with me?
I agree with you, sir.
Okay, all right, very good. Okay, I do not have any further questions, so I appreciate very much your testimony. And thank you for your testimony, Ms. Smith. Mrs. Smith, I said we might take a break. I think these were pretty short, so I think it would behoove us to go on with the third witness.
Agreed, Your Honor. We have one more witness, and I expect he might be the shortest of all.
Okay, very good. So you may call your next witness, Mr. Smith.
Thank you, Your Honor. The company calls Neil Cowan to the stand.
Thank you. Mr. Cowan, would you please raise your right hand? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Put your hand down. Mr. Smith, you may proceed with questioning.
Thank you, Your Honor, and good morning, Mr. Cowan. Could you please state and spell your name for the record, please?
My name is Neil Cowan. That is spelled Neil. Cowan.
And by whom are you employed and in what capacity?
I'm employed by Public Service Company of Colorado as a manager in regulatory policy.
Thank you. And Ms. Kunkel, could we please bring up what's been marked as hearing exhibit 201 in the company's box? Mr. Cowan, do you recognize this document?
I do.
Is to my understanding, this is hearing exhibit 201. This is your affidavit, and I believe this was filed in the company's motion for summary judgment.
Yes.
And do you have any corrections to make or any other changes you'd like to note regarding this hearing exhibit 201?
No corrections.
Okay. And with that, the company would like to offer hearing exhibit 201 to be for admission.
Any objection to what's been marked as hearing exhibit 201 into evidence, Mr. Wagon?
No objection.
Thank you. What's been marked as hearing exhibit 201 is admitted. Mr. Smith, do you have any further questions for Mr. Cowan? You may have.
I do not, Your Honor. Mr. Cowan stands available for cross-examination or Your Honor's questions.
Of course. Mr. Wagon, any cross-examination for Mr. Cowan based on his testimony?
Yes, I have one question concerning his paragraph 7. Perhaps we could bring that up.
Ms. Kunkel, would you please put 201 up?
I will read it if I may, because I find it somewhat confusing. It says, consistent with the statute and the Solar Garden rules, Public Service does not, in administering the program, calculate, certify, or continuously update a subscriber's net annual usage for sizing purposes. This just seems to contradict everything else I've seen that says the company does, in fact, calculate and update my net annual usage.
So there needs to be a question. So is Mr. Wagon's statement correct, Mr. Cowan?
The relationship between the subscriber organization and the subscriber, that's between them, essentially, how much they wish to participate in that garden. The company does not make that determination.
Okay, so maybe I see how that sentence is correct. I guess that sentence refers to numbers that the garden would prepare. So you're referring to the allocation. So is it correct that a better way of saying this would be consistent with the statute, the Public Service does not play a direct role in the allocation of electricity by the garden? With that sentence, I would have no concern. It's just the part that it says update net annual usage that I find confusing, because it doesn't say update the allocation number maintained by the garden. It says we do not update net annual usage. The garden has nothing to do with net annual usage. Net annual usage is, in fact, updated by the company. I believe it's once a month. Isn't that correct?
Could we break that into a question? There was a lot of testifying by Mr. Wagon there. Could we have a question?
Okay, so Mr. Wagon, are you able to, I think I followed you, but are you able to break it into perhaps a couple of questions that are perhaps easier for Mr. Cowan to respond to?
I'll just withdraw the question. I withdraw the question.
Okay, understood. I understand. Do you have any other questions for Mr. Cowan?
I do not.
Okay, I think I do. So let's hold on for just another moment. I think I know the answer to the question, but I just want to, I don't want to assume anything. So once public service determines a customer's annual net usage, how is that information communicated to the subscriber organization, in our case, US Solar?
That's would be more of a program question. I'm not aware how that's exactly done.
Okay, that's fair. Are you aware of what might happen if public service determines that the information previously communicated to the subscriber organization is inaccurate? Do you know what happens next?
I believe, and again, I don't serve in this function, but I believe some sort of communication occurs between the company and the subscriber organization to rectify perceived errors or inaccuracies.
Okay.
Again, I don't
Okay.
run the program.
If you don't have exact it's perfectly fine to say I don't know if you don't know. Sorry, I just need to think of one more minute here. Okay. Do you know of any statute, commission rule, or tariff provision, or company policy that governs the accuracy of information presented through the Solar Rewards community application system?
I mean, other than the cap on sizing the subscription, I don't think the statute or tariff goes into really fine detail. There might be programmatic information that goes into that level of detail, but I don't think the rules go into that level of detail.
And the programmatic information you do not know about, is that correct?
No.
Okay. These are all of my questions. Any redirect, Mr. Smith?
No, redirect it, Your Honor.
Okay. Thank you very much for your testimony, Mr. Cowan. You're excused.
Thank you.
Of course. Let's do this. I think, Mr. Smith, do you have any additional evidence to present?
We do not, Your Honor.
Okay. Mr. Wagon, do you have any rebuttal evidence to present? Rebuttal evidence is evidence that tends to refute what the evidence presented by public service. Do you have any evidence of that nature, Mr. Wagon?
No.
Okay, so now going back to your question at the beginning of the hearing, Mr. Wagon, about closing statements and or written statements of position. What are your thoughts about either or both of these? Start with you, Mr. Wagon.
So you're asking for a closing statement right now?
No, I'm asking if you would like to give a closing statement, or in lieu of a closing statement, would you like to submit or file a written statement of position? And if you would like to file a written statement of position, what do you believe would be a reasonable deadline for doing so?
If the company were to file a written statement of position, then without even seeing it, then I would like to file a written statement of position. If the company is happy with everything that's been put forward in their affidavits, then I am happy with everything put forward in my statement. Although I would like to make a closing statement today, if I could.
Oh, okay. So let's do this. Well, Mr. Smith, let's hear what you have to say about this.
Well, Your Honor, I would say that between the choices, I don't think that if I don't necessarily think that an SOP would be required in this case based on what's been presented thus far. I would say that I think generally my preference would be to do an SOP, but as you've noted in a complaint proceeding, that would be a bit unusual. However, I defer to your judgment and to Mr. Wagon's preference.
Okay, so understood. So I think what I will allow each party to make a relatively brief. I mean, I'm not gonna statement of. I mean, closing statement. Mr. Wagon, you stated that if public service doesn't file one, you do not see the need to file one. So I think we'll do away with the written statement of position. And again, I will give each party, starting with you, Mr. Wagon, the opportunity to make a closing statement. And so when you're ready, Mr. Wagon, you may proceed with your closing statement.
Yes, before I start with that, the statement I made at the beginning, I read from a pre-written document. Can that be entered somehow? Or obviously you can look at the transcript if you care to review anything, but that's sort of inconvenient. Do you want a printed copy of what I said?
No. Thank you for the clarification. I think for a couple of reasons, what you've said is on the record, so it's a part of what I will consider, Mr. Wagon. So I don't think there's a need for it, and there are other evidentiary issues involved with entering a written statement by you, and so I think the short answer is no, and I don't think there's a need for it, and I followed it. And again, there's the transcript of the hearing, and so I don't think there's a need for it. With that, are you prepared to make a closing statement?
Yes, I can just take probably less than 1 minute to make some additional points.
You can take maybe around 5, but that would be fine as well. Thank you. Go ahead, please.
Well, first of all, I continue to think that many of the statements made in the affidavits of the company are simply wrong. I think I've already pointed out the details. There are no double benefits to me by computing the numbers correctly. Also, I believe that my whole complaint here will benefit, if it's approved, will benefit the company, not hurt the company, aside from accounting changes. The company doesn't want to pay me $1 million if they zeroed out $1 million of energy in the opposite way. The company has an interest in my purchasing roughly the amount I need. So I actually believe if the accounting was done correctly, the company would save money. If I'm correct that the company is losing money by doing it this way, you might ask, well, who is gaining that money that the company is losing? It's sort of US Solar, and it's sort of these excess credits that will go to a needy case should I die tomorrow. So I think the company would benefit financially by supporting my view, but the accounting issue is dominant. Number one. Number two, the issue has much been discussed about the company's inability to post the correct figures on the portal. But that that dodges the issue. First of all, the numbers the company wishes to post are not correct in my claim. And I've heard nothing today that changes my view. So the company doesn't even know the correct figures because they have never subtracted or taken into account those negative values. They just take them as being zero. And even if the company was successful in posting, my understanding is that the portal would change, I believe, monthly, so it would have a very limited effect. So that's not the crux of my complaint. The real crux is the 17,211 figure is just wrong, and they should make an attempt to get the correct figure. The issue of a remedy, I just have to leave that to the commission. I cannot really say the proper thing. I will throw out the fact that the tariff allows the donation of credits to that third-party source. If the company should decide that it's if the commission and the company should decide that it's reasonable to give me, say, $300, they could write me a check for $300 and I would donate $300 of credits. And this I mentioned because in an earlier meeting, the company said that there was no mechanism for buying back credits. In fact, there is such a mechanism as I just related. I think those are the only factual points I need to say, and all the other facts are on the table. So again, I thank everyone for their input.
Thank you very much for everything, for your presentation. Mr. Smith, are you prepared to give a closing statement?
Oh, Your Honor, prepared is probably a strong word, but I am happy to give one. Yeah, I'm happy to give one if you're ready for me.
I'm ready.
Okay. Thank you. And Mr. Wagon, despite this being an unfortunate circumstance that I believe has led us here, I appreciate your participation and for the discussion today. Your Honor, thank you for conducting this hearing. I just would like to take a brief moment just to say that some of the statements made by Mr. Wagon in his closing statement appear to be arguments that perhaps should have been asked to witnesses rather than made carte blanche here in a closing statement. But I again expect the judge to give that the weight that it is entitled. Regarding specific claims by the company and the company's position in this case, the company continues to stand by its sworn statements that were entered by subject matter experts. And as explained, the company is confident in their correctness. The situation, I believe, has been fully delineated by our witness statements and throughout the course of this proceeding. The methodology that Mr. Wagon is the subject of Mr. Wagon's complaint is not, as identified, inconsistent with any tariff statute or commission rule. And seeking to change that through a complaint proceeding would impose a duty on the company that is not existent in existing tariff or that is not existing in any existing tariff commission's rule or statute. And I think finally, to me, it does appear to the company that Mr. Wagon, a lot of the allegations made regarding his communications with U.S. Solar are between he and U.S. Solar. The U.S. Solar is not a party to this proceeding. Any statements, any factual circumstances surrounding his contractual obligations or U.S. Solar's contractual obligations are beyond the purview of this commission, are beyond the purview of this proceeding. And therefore, we're not really sure from the company's perspective what could be done differently to force a third party to change the way it uses data. And again, as I stated, as far as the correctness of the data, the company continues to stand by the correctness of his methodology. And it appears to the company that what Mr. Wagon is, the subject of Mr. Wagon's complaint is that he is simply not happy with the methodology that is used. However, not being happy with the methodology utilized is not the same as the company being non-compliant with any of its tariffs or with the commission's rules or with any statute. And with that, we believe that the company should then prevail in this complaint proceeding. And I believe that is all I have to say. With that, the company rests.
Thank you. Thank you both very much. Any last second questions? Wagon?
I'll just say that if that 17,211 figure is deemed correct, I will withdraw my complaint. I do not understand how the company can zero out, essentially ignore some of the energy I sell to them, but not all of the energy I sell to them. It just does not make sense to me.
I appreciate that. And since I've given Mr. Wagon an opportunity to make one statement or a substantive statement, Mr. Smith, would you like the opportunity to have the same would you like the same opportunity, Mr. Smith?
I will choose to let the record stand as it has been displayed here and as has been demonstrated throughout the proceeding, Your Honor. I don't wish to get into a substantive debate with Mr. Wagon here in closing statements.
Right. Okay. Thank you very much.
Understood. Appreciated.
I appreciate everybody's participation, the presentation of the evidence. And I will take this matter under advisement and issue a written recommended decision. I do not know how long it will take me to write a decision. I assure you I will not be sitting on my hands. And I wish you both luck, and thank you very much. And we're adjourned.
Thank you, Your Honor. Thank you, Mr. Wagon. And thank you, Ms.
Thank
Bonet.
you,
Thank you,
Your
Mr.
Honor,
Cooper,
and
Ms.
thanks to
Wagon.
everybody.